Hello everyone. So in this video we are going to discuss article 25, that is first article into right of religion. So article 25, if you see in the slide, right, it extends us freedom of conscience, right to profess, right to practice and right to propagation. So we will study this article in parts, right. At very outset, let me declare that all four articles that you see on the slide, article 25, article 26, article 27 and 28 is applicable to both citizens and foreigners as well. So let us get into slide and let us see what article 25 is about. So it confers upon us these positive right, and this is freedom of conscience, right to profess, right to practice and then right to propagate. So let us see what these all words mean. So first is freedom of conscience. So whatever your wisdom dictates, right, whether you believe in tantric system, you believe in God, you don't believe in God, even to the extent that if you believe in superstition, right, you have right to believe in whatever your wisdom, as long although superstition does have a negative connotation and it should have no place in modern society, but this freedom of conscience, right, extends you that right, of course, as long as it does not violate the restriction that is mentioned, that we will discuss in this article itself. So as long as it is not violating those restrictions, you have every right to believe in that system. So this is freedom of conscience. Then right to profess. So whatever you believe in, whether you believe in God, you don't believe in God, right, you can openly declare that in society. Whether you are a devout Hindu, you are a devout Muslim, you have every right to openly declare, and state does protect that right. The next is right to practice, right. So whether you practice the chandan, tilak, burqa, whatever, right. So state again protects that right as well, right. You offer namaz or anything, right. You have every right to practice your religion. And the fourth and the last word is that you have right to propagate, right. So your religious tenets, whatever you can spread, you can try to influence. So again, this is very objectionable right, which has often been misused, right. We'll discuss the Supreme Court. So you have every right to influence other people by the religious tenets, your religious tenet, and persuade them to join the religion you belong, right. So you will see that in 1967 or 1968, right, this question arose in front of Supreme Court, where the question was that does this right to propagate also include right to conversion as well. So this question to Supreme Court was coming into a context, and the context was that in 1967 and 1968, two states, that is Odisha and Madhya Pradesh, had passed anti-conversion laws, right, that had criminalized fraudulent conversions, right. This led to widespread protest by the Christian community, who interpreted that right to propagate also means right to convert, right. But the Supreme Court's opinion was completely contrary, and you will see that Supreme Court is going to uphold this constitutional validity of these two acts passed by Madhya Pradesh and Odisha, right. So Supreme Court contended the arguments presented by Christian community that this right to propagate also means right to conversion. So persuasive conversion by Supreme Court was allowed, but they clearly told that you have every right to spread and disseminate your ideas of religion, but freedom of conscience, right, should never be influenced by fraudulent means, that is by any kind of inducement or inculcation of any kind of fear among any community, right. So this was about right to propagation, and here a strip that you can see, that is individual right. So individual right and group right, we will discuss that what this individual right, when we have already done that article 26, that is in next video, that why this right article 25 is called individual right and why article 26 is called as group right, right. So we will discuss this thing at least. So let us move to the next slide and let us see what are the grounds of restriction on which rights conferred to us under article 25 can be restricted. So there are actually four grounds, that is public order, morality, health and any other provisions mentioned in part 3 of the constitution, right. So I believe I need not to explain that why on public order grounds, right, these rights can be restricted. So anything, any speech that you deliver, right, or anything, any practice that you do that can possibly disturb communal peace, right, then any of your practice, religious practice, should not be immoral, right. Let us see what health ground. So here is the clip, right? So you will often see that Mamta, the TMC party, right, often resorting to these kind of activity that has been criticized by High Court. But despite criticism, I believe this is the right thing to do, because these kind of things does have capacity to create that public order. And under this provision, you will see that these conflicting processions are often denied permission by the local administration, right? So let us see what is the health ground and how on health grounds, right, rights can be curtailed, right? So you will see if a girl or boy is married before a certain age, right, so that will disturb their growth as well as children that they produce, right, their growth as well. So on grounds of health, this child marriage, the practice of, although you can claim that under right to religion we do have this right, right, but this child marriage can be stopped or has been stopped rather on the grounds of health. Then female infanticide, right, I need not to explain. Santhara, it is a practice of Jain, you need to Google. I don't know whether you know about this Santhara or not. There has been a debate going on, although Santhara is allowed, but this practice had been dragged into Supreme Court on the grounds of health, that okay, this Santhara should not be allowed. Right now the constitutional position is that this is a Jain practice and this is allowed, right. So on grounds of health, this can also be restricted, without offense to anybody watching from the Jain community, right. Let us see what are the other provision, means other provision there is on which this right can be, these rights can be curtailed. So what are the other provisions, right? So any practice you cannot, means article 17, right, it prohibits practice of untouchability. Now under right to religion or under right to practice, right, you cannot claim that right to untouchability is intrinsic to my practice of religion, right, because article 17 has prohibited practice of untouchability. So my point is that anything that is mentioned in other part of fundament, other part of part 3, right, that should not conflict with your religious practice, otherwise that right of religious practice can be curtailed, right. So same thing with article 14, right. So anything that you say or anything you believe in or anything any practice that you want to practice, right, that should not come into conflict with right to equality, that is article 14. So whatever provision, whatever rights has been conferred under part 3 of the constitution, your article 25's right should not get into conflict with those provisions as well. Otherwise court can sit on the judgments and see what is more rational and what is irrational, right. And that is about the other provisions, and that is about this other provision in the part 3 of the constitution. So I hope you do have clarity on what grounds right extended in 25(1) can be curtailed. Let us see other aspect of this article 25. So here in the on the screen, if you could read, it reads, state can manage economic, political, secular activities of a religious practice. So state can manage or regulate. What does this mean, right? You just told me that I do have right to profess, right to practice and propagate my race. So why state is interfering, right? So you will see that in 1960s, 1970s, right, Supreme Court came up with this doctrine of essential religious practice. So let us try to understand what is this doctrine of essential religious practice is, and thereafter we will understand that what associated practice is. So applying Chandan, Tika and Roli, these are considered to be core to Hinduism, right? Thereafter, what time a temple would open and what time a temple would close, that is core to religion. What season it will close its door, right? There are temples in Uttarakhand that remains closed during cold weather, right? That is intrinsic to religion, right? So there is these kind of thing will be called essential practices of that religion, right? Offering 5 times namaz, right? That is a religious practice in Muslims, right? So that will be considered intrinsic to their religion. Similar thing would be with Jains and Sikh and other religion as well. So the point is that there are certain practices which is very core to every religion, and that will get into these essential religious practices, and everything that is not related to worshipping, that will get into associated practices, right? So temples for its management do some financial activities, right? That will get into that associated practices, and that is the point that it is trying to make, right? That a state can manage anything that is not associated with this essential religious practices, right. So, the point, that argument that the state was intervening or state was taking away your right that has been conferred under article 25 by doing this management on regulation, right, that is not correct, right, that is constitutional, right. So, I hope you do have clarity on what is this essential religious practices and associated practices is. So, applying of Chandan Tilak, how many rounds worshipper will take, right, of sanctum sanctorum or way of worshipping is called essential religious components, and in these areas, right, there will be no state intervention. However, anything other than that is not related to worshipping, right, that will be considered associated practices, and state does hold right to regulate those affairs. Let us see the other provision. Now, the other provision says that opening of Hindu religious institution of public nature, right, for social reform for all classes of Hindu. Again, this is self clear, right, I need not to explain, because even at the time of constitution making, you will see that a large section of our society was not allowing people belonging to the lower strata to the temples, their entry was not allowed, and that is why you will see that opening of Hindu religious institution of public nature, right, not somebody's personal temple, right, for social reform for all classes of Hindu, right. And Hindu, when you say that Hindu, right, Hindu here means every religion that derives its genesis from Hinduism, right. So, be it Buddhist, be it Sikhs, Jains, right, every religion that derives its genesis, right. So, word Hindu includes all those religion. Now, here's it is additional thing, this is not mentioned in Laxmikant. There are two words that I have used here on slide. There is something called social reform and there is something called reform of religion, right. These two words have a different meaning. Again, I am not getting into vocabulary, you can just pause this video and ponder over what these two words mean, right. So, here you say that for purposes of social reform, you can open up Hindu temples, right. So, that is part of social reform, right. But in recent time, in last 20 or 30 years, you will see that Supreme Court, right, has entered into what is called reforming of religion. In Sabrimala case that we are going to discuss, we will see that how it has ventured into something called reform of religion, right. So, under the garb of social reform, right, Supreme Court itself, from their judgment, it is not my opinion, so from their judgment itself, right, that under garb of this social reform, right, Supreme Court should never get into, or courts of this land should never get into what is called reforming of the religions, right. So, let us see what is this social reform and how we can separate it from reform of religion, right. So, when you are making sure that every caste should enter into the temple, right, when you are ensuring their right, that is part of social reform, right. Then ensuring gender neutrality, right, into temple entry, that is also social reform. But in case of Sabrimala, that you see, again it is this is my opinion, right, this is not Supreme Court observation, right, and in my opinion, in Sabrimala case, if you would have followed, and in case if you have not followed, right, please make sure कि आप उसके case को पढ़ें, right. So, in Sabrimala case, you will see that Supreme Court has allowed entry of every gender and belonging to every age, right. So, their contention, those people who worship Ayyappa, right, their contention was that it is only one of 20,000 temple where Ayyappa is believed to be practicing celibacy, right. It is not for the biological reason or biological impurity that a certain age of woman has, right. It is not because of that that their entry is prohibited, right. There are 20,000 temples spread over South India belonging to this Ayyappa, right, and Ayyappa is a deity, right, he happens to be as a deity, he do have legal rights, right. So, in that one particular temple in Sabrimala, right, their adherents of Ayyappa claim that in that particular temple, he is believed to be practicing celibacy, right, and as a legal entity, right, when you are extending as a citizen to me right to practice my religion or right to practice my belief, right, what about this? So, that legal entity, that deity should not be given the rights that he believes in. If he is believing that at particular place I am practicing celibacy, right, I should be given that independence in garb of maintaining that right to equality, that was article 14 of those women's, right. You cannot get into what is called this reform of religion, right. So, that was my argument. So, with this argument I am closing this article 25, right.